know. Let's do this. What's up, Windy Hill Podcast? Today, a landmark Supreme Court case was just decided. McDonald v. Chicago has been a highly anticipated decision for gun rights and gun control activists alike. Otis McDonald sued the city of Chicago last year over a statute that banned handguns in 1982 in the city. McDonald, who was a janitor and avid hunter, he felt that it was a crime that he couldn't go and defend himself within his own city, right? He couldn't go buy a handgun to go not fight against, but to feel safe amongst the other people who own guns illegally. It was horrible. So because of this, he filed a lawsuit, and so did the NRA. This comes in lieu of the DC v. Heller case that just happened 2 years ago. Gun rights activists pushed to lower regulation on guns in those cases, and let's hear more from our legal analyst, Rob Chapman, about the decision of this case.
Thanks, Evan. After the district courts and the Seventh Circuit Court of Appeals sided with Chicago, McDonald appealed this to the Supreme Court. In a tight 5-4 decision, the Supreme Court sided with McDonald. Justice Alito wrote the majority opinion with Justices Roberts and Kennedy in full support. Justices Scalia and Justice Thomas wrote concurring opinions, while Justice Breyer and Justice Stevens wrote the dissent, along with Justice Sotomayor and Justice Ginsburg.
What were the arguments that each side made in the case, Rob?
Well, Evan, the plaintiff argued that the Second Amendment was applicable to the states and the federal governments alike. They claimed that the Due Process Clause and the Privileges and Immunities Clause of the 14th Amendment incorporate the Second Amendment to the states. These state that no citizen shall be deprived of life, liberty, or property without due process of the law, and that no state shall make a law that abridges the privileges or immunities of the right of the citizens of the United States. The plaintiff cited the practice of selective incorporation in their argument, which has been the gradual application of the Bill of Rights to the states. They likely used the momentum piggybacking off of the decision in Heller v. DC, which struck down a similar ordinance in our capital. On the other hand, the defense argued the Second Amendment had not and should not be incorporated to the states, and that local governments should be allowed to create gun laws that reflect the situation within the state or municipality, as happened
Rob,
here.
can you share with us a bit of the justice's insight and the justice's opinion on this case?
Well, Evan, Justice Alito said in his opinion that the Due Process Clause of the 14th Amendment incorporates the Second Amendment to the states. He stated, quote, "Our decision in Heller points unmistakably to the answer. Self-defense is a basic right, recognized by many legal systems from ancient times to the present day." This reaffirmed the decision that they made in the DC versus Heller case. Justice Thomas wrote in a concurring opinion, stating, "Applying what is now a well-settled test, the plurality opinion concludes the right to keep and bear arms applies to the states." However, in his opinion, Justice Thomas states that he does not believe that the Due Process Clause is the easiest way to incorporate the Second Amendment, and rather that the Privileges and Immunities Clause is a more direct and more straightforward way. In Justice Breyer's dissent, he stated that there is no evidence in the history or language of the Second Amendment that would make it fundamental, and therefore he believes that it ought not to be incorporated to the states. Justice Stevens' dissent, he disagreed a little bit with Justice Breyer. He said that he challenged the Founding Fathers' intent, or the typical belief behind the Founding Fathers' intent towards the Second Amendment. He doesn't believe that the Second Amendment grants private citizens the right to bear arms solely for the purpose of self-defense. Justice Scalia actually wrote to contradict Justice Stevens' opinion, stating that the right to self-defense was fundamental to the United States.
Thank you, Rob, for that great conclusion. The worst part about this case, in my opinion, is that there's no clear conclusion, as both sides are claiming victories with the court case decision. The decision does not outright protect all firearms. However, it does apply the 14th Amendment to the states through selective incorporation. Moving forward, I think it's probably more likely that more gun lawsuits like this will pop up around the states, just because this one has succeeded. Who knows what the effects of this will be afterward? I don't think we'll know for many, many more years. But one thing is for sure. It's been Evan and Rob on the Windy Hill Podcast. Put your hand on the rock.
We're not doing that.
Rob, put your hand on the rock.
No.
We'll see you next time.